NACDL is the association of the nation's criminal defense bar.
I have 3 takeaways today. They'll make sense by the end of the talk. Challenging the validity of a trade secret. Your burden should be relevance, not necessity. And if you lose on those 2 fronts, you want to get a protective order, disclosure. You don't want total withholding of the information from the trade secret owner. So first, why talk about trade secrets at all? This conference is about challenging law enforcement technologies, surveillance and other technologies. Many of these tools and technologies are developed by private companies who, as we heard at the last wonderful panel, argue that they have a trade secret right. This conference is about law enforcement technology. Many of the technologies law enforcement is using are developed by private companies who assert that they have a trade secret right to withhold relevant evidence from you and your clients. When you move for statutory discovery, Brady disclosures, or your subpoenas to third-party developers, and I want to emphasize something from the last panel, send subpoenas to third-party developers, please. Often we're not getting the subpoena litigation, just the discovery. Do both, please. You might hit a roadblock. Here's some examples. ShotSpotter, we'll hear about later today, has asserted trade secret right to block source code disclosure for defense subpoenas. CPS, it's a company that develops malware law enforcement uses to investigate distribution of child sexual abuse materials online, has asserted trade secrets to block defense subpoenas for source code. The DNA software you just learned about asserted trade secrets to block defense subpoenas for source code and other information. Companies that sell face recognition tools, companies that build Stingray devices that surveil your cell phone location and potentially content, companies that develop device extraction, password cracking technologies, have all asserted trade secret claims in their code and often in public records requests, but we can anticipate they'll make those same claims if you try to get access to information in a criminal case. So what do? 2 steps. Step number 1, please challenge the validity of the trade secret. Somebody asserts they have a trade secret right to block your subpoena. Maybe they don't actually have a trade secret. What's a trade secret? There's a lot of different forms of intellectual property. You thought you were a public defender, a criminal defense attorney, now you're an IP attorney. There's copyright, trademark, patents, trade secrets. Okay, these are all different forms. They have substantive elements that are required to prove to get a claim. In a lot of criminal cases, you see this other word, proprietary. What does that mean? Nothing. It means nothing. There is no legal right to proprietary information. You don't get protection unless you meet the elements of a substantive field of intellectual property. And guess what? Trade secrets is the only one that justifies withholding information in any context. Because copyrights, it's in a book, trademarks on products in the market, patents, products in the market too. All those things protect information after the information's been publicly disclosed. So it's got to be a trade secret. If they say proprietary, they better mean trade secret or they got nothing. So what do you need to prove to get a trade secret? In general, there's 3 elements. The thing's got to be actually secret. Can't be generally known in the industry, not to the public, the industry. Can't be readily ascertainable, like you could just figure it out easily from a product on the open market. That secrecy has to give the thing economic value. And the company has to have protected the information with reasonable security precautions. Oh, here's an example, sorry. What does count? Coca-Cola, the recipes, the famous one. Google's PageRank algorithm counts. Pre-release prices, you know what your marketing strategy is going to be, can count. These are all subject matter areas that can count. Customer lists, all these things. There's no real subject matter limitations beyond those elements that I just said you have to prove. But what doesn't count? Stuff that's in the public domain already. So if a company has taken a bunch of code from GitHub and put it into their product and called it a trade secret, they might be wrong. Maybe it's not. Stuff that's generally known in the industry, it's obvious to an expert. Something that has no economic value. So the name of my middle school crush, totally secret, no economic value. It's not a trade secret. Who thinks taxpayer-funded information developed by our government representatives counts as a trade secret? If you think so, please raise your hand. Got one hand? No, it went down. Nobody thinks taxpayer-funded information owned by the government counts as a trade secret. I'm sorry to tell you, the government can own trade secrets. Maybe they shouldn't. It's different than copyright. Federal government can't own a copyright. Documents developed by the federal government, copyright belongs to the people. Not so with trade secrets. So even if something's developed in-house in a lab, taxpayer money, they can claim substantive trade secret right. So my first takeaway, I said challenge the validity of a trade secret. If you can, get pro bono IP counsel to do it for you. There's people that specialize in this. It's complex litigation. Get them in, get them to challenge that there is actually no valid trade secret and see whether the companies claiming this really want to have that fight. All right, you lose on that. What do you do? If it is a valid trade secret, what does that mean in terms of evidence law? Right, you're not litigating a trade secret claim, you're litigating a discovery motion. So what does evidence actually give trade secret owners? One argument. There is no right to withhold trade secret information in criminal cases. Maybe we have an evidentiary privilege for trade secrets in civil cases, but maybe we don't have one in criminal cases. So here's something that I think is going wrong in a lot of the litigation I see. Defense counsel, when they get one of these motions to quash, often understandably say, I need that information. It's necessary. Right? The company says it's not necessary, you say it is. I have confrontation rights, I have a right to present a defense. I can't evaluate this any other way, it's necessary. Makes sense that you would approach it that way, but actually it's the wrong burden. You should not have to prove necessity unless there's a privilege. You should only have to prove relevance. Relevance is your baseline subpoena standard. It gets heightened when there's a privilege. But if there is no evidentiary privilege, you only have to show relevance. Well, how come there might not be an evidentiary privilege? Well, the Civil Code has protections for trade secrets that are in it, the Federal Rules of Civil Procedure. Criminal procedure rules are silent on trade secrets. There's no federal precedents, very few state precedents, that say there's a trade secret privilege in criminal cases. Here's a state example. California's evidence code has statutory privileges, and they actually have them divided and separated out. In general, then they have specific, criminal-specific privilege provisions. And the criminal-specific privilege provisions provide for protective orders, sealing, and courtroom closures. But they don't provide for withholding information. They don't provide for raising the burden on your discovery motion from relevance to necessity. So maybe that doesn't exist. Policy arguments. Why should courts not create a trade secret privilege in criminal cases where none is here already? Well, it's harmful. It sends the message that the government values intellectual property as much or more than life and liberty. It's unnecessary because, as we heard at the last panel, in civil cases, this stuff is disclosed all the time under a protective order, which is the full reasonable protection intellectual property owners should have in this context. It overprotects intellectual property to raise the burden or to quash your motion entirely, because in the substantive trade secret law, to get an injunction stopping somebody from using a trade secret, you got to show the court that they're trying to steal your stuff, that they have threatened or actual misappropriation, but you and your experts aren't trying to steal the trade secrets from law enforcement technology developers. You're trying to scrutinize them. In defense, scrutiny is not a business competition. Couldn't win a trade secret misappropriation claim under the substantive law. You shouldn't win it in your discovery either. They shouldn't win it in discovery either. Fails to serve the purpose of trade secret law. Trade secret law is actually about enabling limited disclosures of information, which makes sense because you don't need the law to protect your information if you never tell anybody about it. You only need trade secret law if you want to disclose to subcontractors, business negotiators, the government for regulatory oversight. So trade secret law is supposed to facilitate limited controlled disclosures, and it should do that in your cases too. And finally, it doesn't serve the purpose of privilege law because privileges are supposed to give protections inside court to information we protect outside the adjudicatory context. We don't protect the information outside court. Why would we give it more protection in evidence law than we give it in the substantive law? Okay, so argue that there is no trade secret privilege in a criminal case. That means your burden is relevance, not necessity. And final takeaway, what if you lose on that? If you lose on that, you got a privilege. Okay, what does the privilege entitle the developer to do? It should not entitle the developer to entirely withhold relevant evidence from the defense. It should, at most, entitle a developer to a reasonable protective order, which is challenging enough, as we heard from the last panel. And quick note, there is this exception in most of the civil code evidentiary privileges, which says doesn't apply even if it's going to conceal fraud or otherwise work injustice. So those are the three takeaways. I do have an extra bonus, which is if you fail in getting source code or other trade secret information, I guess source code, no, other trade secret, all sorts of it. If you fail in getting it from the developer or from the government, see if you can get it from a cloud provider. So I worked with a team litigating a case where we couldn't get source code from StarMix, tried to get the StarMix source code from GitHub. Well, that raises a whole bunch of other really interesting issues around privacy statutes that are used to block subpoenas for remote stored communications content, and Jumana and the Fourth Amendment Center and NACDL have a template motion in their motion bank if you want to litigate that issue. So here's the three takeaways. Challenge the validity of the trade secret, step number 1. Step number 2, there's no privilege, so your burden should be relevance, not necessity. You lose on those two, and your last point is, well, okay, if there is a trade secret and there is a privilege, it should only give a protective order, it shouldn't give total suppression. I've got 1.5 minutes. I'd love questions. That was a little bit of a speed, but they called it a flash talk, so I'm available and would love to hear from you. Again, thank you so much for having me, and thanks to the organizers.